Start. According to the FIR, Imran made indiscriminate firing at the spot and create panic. Full stop. No other overt act whatsoever, is attributed to accused. Full stop. This court has gone through the record, no crime empty was recovered from the spot to prove that indiscriminate firing was made by the accused along with three unknown accused. Full stop. The matter of common intention would be discussed in later paragraph of this judgment. Full stop. According to application, accused fired a shot from his firearm which hit abdomen of injured who fell down on the ground. Full stop. The learned defense counsel, while taking exception to prosecution version, maintained that this injured is Sheikh by caste and there was no reason for the accused to cause injury to him. Full stop. According to him, the complainant party is Jat by caste and accused party is Rajput by caste, and this injured is aged about 12 years. Therefore, there was no grudge for the accused party to fire at this boy. Full stop. He strenuously argued that this injured was injured at some other place and was introduced in this case by the prosecution with mala fide intention to create evidence of injured witness against accused. Full stop. The London Defence Counsel has referred to cross-examination of PW6, who stated in cross-examination that injured is Muslim Sheikh by caste. Full stop. PW6 stated that accused exhorted Al-Alkara to teach a lesson to Rafiq for their insult, whereas PW7 stated that a dispute of motorcycle between Rafiq and accused persons was motive for the accused. Full stop. In this way, there is glaring discrepancy between statement of PW6 and PW7 regarding motive part of the occurrence. Full stop. No other witness has been produced by the prosecution to prove motive. Full stop. In these circumstances, the prosecution has failed to prove its motive. Full stop. Furthermore, no crime empty was recovered from the spot, so no question arises for the comparison of crime empty with the crime weapon. Full stop. In these circumstances, these recoveries are inconsequential. Full stop. Para. Now, this court would like to discuss as to whether there was common intention between the accused or not. Full stop. In the case of section 34, it is well established that a common intention presupposes prior consent. Full stop. It requires a prearranged plan because before a man can be vicariously convicted for criminal act of another, act must have been done in furtherance of the common intention of them all. Full stop. Accordingly, there must have been prior meeting of minds, several persons can simultaneously attack man and each can have the same intention, namely the intention to kill, and each can individually inflict a separate fatal blow, and yet none would have the common intention required by the section because there was no prior meeting of minds to form a prearranged plan. Full stop. In a case like that, each would be individually liable for whatever injury he caused, but none could be vicariously convicted for the act of any of the others. And if the prosecution cannot prove that his separate blow was a fatal one, he cannot be convicted of the murder. However, clearly an intention to kill could be proved in his case. Full stop. It may not be out of place to mention here that a line of distinction is to be drawn between same or similar intention and common intention. Care must be taken not to confuse same or similar intention with common intention. The partition which divides their bonds is often very thin. Nevertheless, distinction is real and substantial, and if overlooked will result in miscarriage of justice, full stop. The inference of common intention within the meaning of term in section should never be reached unless it is necessary inference ded- deduct, deducible from the circumstances of the case, full stop. It must be shown that criminal act was done by one of accused in furtherance of the common intention of all, full stop. Common intention within the meaning of the section implies a pre-arranged plan, comma, and to convict the accused of an offence applying the section, it should be proved that criminal act was done in concert pursuant to pre-arranged plan, full stop.